So with that in mind, allow me to actually give you a brief outline of what we are going to present on today in relation to cross-border data, the cross-border transfer of personal data. And one, we are going to start with the legal basis. Why do we have this? And also, we'll take you through the general principles for transfer. And also, we will talk about appropriate safeguards. What does it mean to have deeming of appropriate safeguards? What are the binding corporate rules in relation to cross-border transfer of data? And in certain circumstances, we have experienced passive transfer of personal data without us knowing. So we are also going to have a presentation on that as well. What are the agreements that need to be put in place by entities that engage in cross-border transfer of personal data? We'll also take you through Schrems 2 decision, which actually brought out the issue of data localization, and that any kind of personal data that's processed within a certain jurisdiction should always be retained within that jurisdiction. And if at all there is a transfer, then what should be done and what are the documents that are supposed to be signed by the transferring entities and the receiving entities. Also, we are going to discuss transfer impact assessment, how it's done and what is it actually and how it's conducted. We are also going to have a presentation on the impact of Data Protection Act on your entity, especially entities that are more engaged in cross-border transfer of data, and we will discuss in depth how cross-border and the laws affect them. We'll also give a few ways on how we can mitigate such circumstances and how you can comply with the law in relation to cross-border transfer of personal data, and give recommendations. So first, I'm going to take you through the legal framework of what brought about the aspect of cross-border transfer of personal data. So the government enacted a robust legislation to secure the rights of data subject and oversee the policies and practice of intermediaries. So the legal framework touches on the laws, that is, what are the regimes in relation to data protection. So we have the Data Protection Act of 2019 and its general regulation. We will be asking ourselves, why do we have these laws, and what is the history behind it? And let's maybe take a step back. We have the Constitution of Kenya under Article 31. And what Article 31 C and D states that is everyone has the right to privacy in person or in relation to information, and even their personal capacity or in their own entity as a human being. So in that regard, it means that our rights as individuals are protected in relation to how we share our information, whether personal, whether sensitive. It touches on different fields of privacy, even including maybe the security of where you stay and where you live as an individual. Because at the end of the day, all aspects touching on our privacy must be respected. So the commissioning office and the that is in charge, let's call it the authority, is the Office of the Data Protection Commissioner, which was established by the Data Protection Act of 2019. And this office has been there, and I believe actually it's been running for more than 100 days, if I'm not wrong, because the office came into force last year, and the operations are actually getting active as time go by. So continuation of the legal framework, we have these laws to regulate the processing of personal data, the rights of data subjects, and for the obligations of data controllers and processors. It also specifies the obligations of the data controllers and processors. It is also designed to bring the protection of personal data from misuse, and it facilitates lawful use of personal data. And that's why today we are going to talk about cross-border transfer of personal data and how a company or an entity dealing in the same or having engagement that go beyond our borders will be able to comply with the same. There are a few concerns that have arisen as a result of data transfers, and mostly the assumption is that there's a data protection regulation in the country for registration of a company or an application where the data resides, because sometimes we have data that is stored within the institution that is in premise, and in some instances you also have data that is in cloud, and I believe most of the companies are now shifting to storing their data in cloud because of the capacity and the amount of data they process. So in that regard, we realize that globalization and localization dictates that the standards for data protection and privacy in terms of where the data is processed and stored should be governed by law. So there are a few terms that you are going to interact with as we go through this presentation, and one of them is the term data transit. What does data transit mean? And we also have a party, that is a recipient, and the transferring entity. So these are some of the terms that we will come across. When we talk of data transit, it refers to information that is moving from one origin, let's say one country to another. It could be from Kenya to South Africa and vice versa. And maybe this information at some point would get through another country. So this is what we call data in transit, because the moment this data is passing through, I can give a perfect example of maybe Zambia or Zimbabwe before it gets to South Africa. So it means that this is data in transit, and the Zambian or Zimbabwean states don't have the right to intercept or actually assess this kind of data in transit. Then we have recipient, which is the data importer. So the recipient is the person or the entity or the country that's going to receive this data in transit, and the transferring entity is a country, or rather an entity that deals with transfer or is transferring this data for purposes of discharge of services, or rather maybe a fulfillment of a contract. So moving on, we have data localization, and data localization is the legislative, or rather a regulatory requirement to domicile specific data in Kenya or the jurisdiction in which the legal requirement is enacted. So when you talk of data localization, normally it refers to a situation whereby the data is processed in Kenya. If this data is processed in Kenya, that means this is the country of domicile, and this is where we should have this data stored. Then we have this aspect that in as much as this is happening, it means we cannot always have all our businesses conducted in Kenya. For us to carry on business and transact, at some point you have to cross borders. And I believe with the AFCAT and all that, it is very evident that data localization becomes a challenge, and it's only a reality in paper. But practically, it's something that we really need to look at and deeply have a discussion over. Then Section 50 of the Act and its regulation, which is Section 26(1) of the General Regulations, further provides that the Cabinet Secretary may determine certain types of processing which may only be conducted through a server or data center located in Kenya on the basis of strategic interests of the states or for the protection of revenue. The requirements on data localization are detailed in the General Regulation, and this one will not go really deep into it today. We will look to have this conversation another day. But then the question will be here that what are we doing to ensure that we balance the aspect or the principle of data localization, and at the same time have it create that balance or strike a balance between data localization and cross-border transfer of personal data. Because at the end of the day, we have to trade, we have to move around, we have to carry on business. So we need to create that balance. So I'll welcome Brenda to take us through the strategic purpose in relation to cross-border transfer of data and how it comes about. Welcome, Brenda. The floor is yours.
Thank you. Thank you so much, Cynthia. Just want to confirm if you can hear me.
Yes, I can hear you loud and clear. I hope everyone else does.
Okay, so what you're seeing on our screen is a continuation from the data localization, and Cynthia has correctly defined that for us. Cynthia? Okay. Perfect. So when we're talking about data localization, as you've seen, regulation Act in section 50 of the Act and regulation 26 has set out some of the, some of the pointers you need to know when you're localizing data. And I would wish to request Cynthia if she could go to the slides which show us what, from data localization, what it is. Okay, so for purposes of strategic interest of a country, many countries, when they are looking at their personal data, have chose to have their data stored in the country of, residence. And Kenya is one such country. It has set out certain parameters that data controllers and processors need to put in place certain kind of data for strategic interest to be stored or domiciled in Kenya or have a serving copy in Kenya. And this was brought about with you remember the Fungua server saga we had in 2017, when the Supreme Court case, the presidential elections, when we were being informed that certain servers were outside the country and they could not be accessed because the person who the service provider was not awake at the time when we wanted to access the server to be able to enforce a legal claim. So with that, the Data Protection Act was very clear about the certain parameters that need to go into data localization, and shows that certain sets and kinds of data needs to be domiciled and resident or stored in the country for strategic interest and purpose. And why all this? It's because many countries would like to maintain their sovereignty and also the economic interest and the social interest attached to, the state being able to protect their citizens. So they would like to have the entire autonomy of their data. And that's why for Kenya, we chose this approach where you can have either a copy in Kenya, or you should entirely store your data in Kenya. And there are so many concerns about, do we have the capacity to, to provide these services? Some are saying it's a bit expensive to localize data, but the government, I believe, is working on initiatives to make this possible for service providers or controllers and processors in the country to have them be able to, to access these services at a cost that is reasonable. And we have some data centers. We recently launched the Konza City, and it's one of the biggest data centers in Eastern Central Africa. Cynthia, you can move on. So these are the kind of data that needs to be stored in the country. If you could go to that slide, which was showing us what kind of data needs to, So once you look at regulation 26 of the general regulations on data protection, you'll see that if you're administering a civil registration or legal identity management system, you need to store your data either in Kenya or have a copy. What are the civil registration entities? These are like the Register of Person, Register of Marriage, Register of Births and Deaths. All these are civil registration entities which must ensure that their data is either in Kenya or they have a copy in Kenya. Another institution or organization that should store their data in Kenya is any institution that conducts elections. And here we can give the example of IEBC. So IEBC for Kenya is required to have their data localized or have a serving copy. And then if you're overseeing any system for administering public finance, so you have to have your data in Kenya. These are examples that, like the ERP systems that we have, or the IFMIS systems, you need to have your data localized. Then we have, if you go to Section 20 of the Computer Misuse and Cybercrime Act, there are certain systems that have been designated as critical infrastructure. So if you go through each one of them, if you find you fall under those, and I know ICT systems as such are one of the examples of critical infrastructure, then you need to also store your data in Kenya. And then we have schools, all the schools for purposes of education, especially our primary schools, our basic education, you need to have your data either in Kenya or have a serving copy. And then if you provide primary or secondary healthcare, again, if you're from that sector, you need to have your data in Kenya or a serving copy in Kenya. Cynthia, you can move on. So, so this is what I was coming to on what we meant by having a two-tier. This means that you can have your data localized entirely and have it stored in a server in Kenya, or you can either have it stored wherever you would like to have it stored, but you need to have a serving copy, at least a copy in Kenya. You can move on. So moving on to cross-border transfer, the topic which we are connecting with data localization. What is cross-border transfer? And this is the transfer of data moving from one country to another country. This is basically data moving from one internationally. And why are we having cross-border transfer? This is because we are increasingly doing a lot of e-commerce, and that's for the basic reason that as businesses would like to access our customers' transactions, would like to analyze their behavior, and some of this we can only do it if we if we transfer data from one organization to another. And this comes to, if you're a company that has a global footprint, you usually have to transfer your data from one country to another. And we've been taken through some of the terms, the data in transit, the recipient, the transferring entity, and this will all make sense as we go through. So just like any other countries who have enacted a data protection law, we as Kenya have not been left behind. Part of what is entailed in the law is, regulating how data is transferred from Kenya to another, another country or an entity that is outside the country. So we have Section 25 H, which sets out that you cannot transfer data outside Kenya unless there is proof of an adequate data protection safeguard or you have received consent from the data subject. And why are we doing this? Because if Kenya is protecting their personal data, would like that if it is to go outside the country, we have equal protection or safeguards. Because again, as I said, we want to bring back the autonomy of your personal data, because it's a constitutional right. So you have the right to have your data safeguarded. And the good thing about regulating transfer of personal data is that businesses and organizations are not hampered from, transferring personal data to other countries. It's only that we need to make sure that whatever data is transferred outside the country is protected. So in the regulations, we have the whole of Part 5, Part 6, which is Regulation 39 to 48. It does set out the principles of how you should transfer personal data. So just in summary, it says that you can only transfer personal data outside of the country if you have demonstrated, and I'm talking about the controller or the data processor, to the data commissioner, that where you are transferring this personal data, there are adequate safeguards for the protection of this data. And then you have to give proof to the data commissioner that there are appropriate safeguard or there are commensurate data protection laws. What do I mean by commensurate? Is that the data protection law of the country you're transferring this data almost or exactly mirrors the data protection law in your country, and that is Kenya. So we have countries like the EU, the GDPR. If you look at it, it almost mirrors what the certain kinds of safeguards that we have in the law in Kenya. Moving on to the general principles of transfer of personal data. So a data controller or data processor shall, before transferring this personal data, ensure that there are either appropriate data protection safeguards, or there is an adequacy decision made by the data commissioner, or the transfer of this personal data is necessary, or they have received consent of the data subject. So this, you must ensure that one of the following applies to you if you want to transfer personal data outside Kenya. Cynthia, you can move on. Okay, so we are going to go into the nitty-gritties and the details of each of the, the tiers of what you can look at if you're a data controller or a processor and you want to transfer personal data outside the country. So one of the things we have is the appropriate safeguards. So as a controller and a processor, you need to look at the country where you're transferring data, and you need to determine that they have either a framework or legislation that is equivalent to our Data Protection Act, and is binding on, the recipients of the data that you're transferring. Or as a data controller or a processor, you do like a transfer impact assessment to just determine that third country, that international organization, do they have, do appropriate safeguards exist to protect the data that you're going to transfer to that country. Moving on. So while you're determining the appropriate safeguards, make sure that you, as a data controller or a processor, you're obligated to document the transfer, and then you have to provide the documentation to the data commissioner. Of course, this is on request, and you know that from time to time, these things will be under review by the Office of the Data Commissioner. Like they will carry out periodic audits. So this, if you are required to give this documentation, make sure that you have it. And then the document must be, you must state the date. So this is obvious, it must be in writing. So you must state the date and the time of the transfer, the name of the recipient, and then the justification of the transfer and the description of personal data you're transferring. Sometimes you may be transferring data that is data of children. That is very key. Because the Data Protection Act in Kenya is very key on the protection of children's data. Maybe you're transferring health data. Maybe you're transferring sensitive personal data, which the Act is also very clear that it requires certain protections. So you must make a description of the personal data you're transferring. Moving on. So going into the nitty-gritties, what if you're a controller and a processor, how will you know that the country or the organization you're transferring this data has what we call deeming of appropriate safeguards? What are the pointers you need to look out for as you're even going to seek this approval from the Data Commissioner's office of what you need to look for in that country to determine whether on first basis they have appropriate safeguards of the personal data. So we have, if a country has ratified the African Union Convention on Cyber Security and Personal Data, then that is deemed as a deeming appropriate safeguard. Or if the data, that organization has a reciprocal data protection agreement with Kenya, that again is deemed as appropriate safeguards. Or if there's a contractual binding corporate rules among the concerned groups or the entities, then that's deemed an appropriate safeguard. Let's go into the details of each. So one of the key pointers we looked when the law was being drafted is that we have currently, we know that the EU has the EU GDPR, that's the General Regulations on Data Protection, and that's like a regional which governs how they process personal data for all their entities all over the world. So you have to subscribe to those regulations for Africa, we have something similar, which we call the Malabo Convention, or the Convention on Cybersecurity and Personal Data Protection. However, it has, for it to be enforceable, countries need to ratify it. And for Kenya, we are still on the journey to ratify this so that we can have sort of a regional regulation that can guide member states on how to protect personal data. And key among the protections of personal data is allowing that free data flow. And if a country has this regulation or this convention ratified, then you can deem it as a country that offers adequate protection to the personal data you're processing. Okay, I can see a question: how many countries? From research, they say about 28 countries. I will have to confirm that, and Cynthia can help us confirm that at the moment. So Kenya, we are still on, in the process of ratifying the same, but the law is clear that if a country has ratified the same, then we can deem it that it has the adequate protections. And why would we deem a country who have ratified this convention as having adequate protection? Is because it sets out certain laws, including institutional frameworks for protecting personal data. And then it also brings together the authorities, the different data protection authorities. And also it sets out obligations on governing personal data. Then it sets out, of course, very key, the data subjects' rights. And then it has a whole framework on cybersecurity. Moving on. We have our second pointer, and it's binding corporate rules. So we do realize that not all countries, have a data protection framework in place. However, an organization is not hampered from, transferring personal data to that country. So what are binding corporate rules? These are rules that are formal decisions which have received approval from the data commissioner that guide certain industries, guide certain organizations, and they are internal. So if you're a certain group, you can come up with internal policies which will guide how you protect and safeguard personal data. So this is also included in our Act. So they are legally binding and they are enforceable to every member of a group. And then they expressly confer enforceable rights on data subject with regard to processing their personal data. So you can be an entity here in Kenya, and you're also an organization which transfers personal data outside your sister entity or an organization outside Kenya, and you have these internal policies or corporate rules that guide you on how you process personal data, and there are certain thresholds that these rules have to meet. So it may be the threshold of having having a framework for enforcing data subjects' rights. It can be the principles of data protection. All that has to be included in these binding corporate rules. Moving on. So these are some of the requirements for binding corporate rules, and I've said these have to be lodged to the data commissioner for approval and consideration. So these are the requirements. The structure and contact details of the group have to be in there. The data transfer or set of transfers, including the category of personal data. So you can see that this is flexible. So different entities can come up with this, and once approved, they can always, deem that they have appropriate safeguards to the country that they are transferring personal data. So it must be legally binding in nature, both internally and externally. So you cannot just bring policies that do not have a legal backing. They must be binding on the parties. Then they have to apply the principles under the Data Protection Act, and those are under Section 285. And then they have to set out the rights of the data subjects. And then they have to set out complaints handling procedures, and then mechanisms within the group or an group of undertaking, and ensure verification of the compliance with the binding corporate rules. Moving on. So, and then we have a third one, which is the adequacy decision. So when you're transferring personal data outside Kenya, you can also rely on what we call the adequacy decision. So this is a decision that is made by the data commissioner. And what does this decision do? This decision comes about when the data commissioner designates or decides that after review and after consideration that a country has the adequate protections and the personal data protections, and they have adequate level of protection of personal data. So they may not even have, they may have a law in place, but we would like it we would like to ensure that it offers the necessary protection, or they may not have a law in place. So what this does is the data commissioner can decide or can say that Ireland or America or UK, they have commensurate data protection laws, and they can list them on their website and say that if you're transferring personal data to X country, we are sure we have worked with them and we know that they have adequate level of protection when it comes to personal data. So this is something that many countries have come up with. The UK has come up with it. Many countries that have advanced well in data protection and have been there long enough have this list of countries. They have lists of organizations, and we are hoping that as Kenya, we will get there by and by. Moving on. So another level of or permitted transfer of personal data outside the country is if you're transferring this data out of necessity. It is necessary for you to transfer this data outside Kenya. I'm seeing questions coming in. I hope Cynthia will mark them so that we can answer them as we go by. So we have out of necessity, these are some of the purposes or the justification of transferring data outside Kenya. If that is, if you're performing a contract or you have a contractual obligation, or you know, you're doing a conclusion of performance of a contract in the data subject's interest, or it's out of public interest, or you're establishing or defending a legal claim, or it's vital for the data subject for you to transfer their data outside Kenya. And I know many of the healthcare providers many times have had to do this for the interest of the data subject, and or you have a compelling legitimate interest as a controller or a processor, and you can justify this, then out of necessity you can transfer to an entity which country may not have a data protection framework, but so long as you are able to prove that they have the protections and the safeguard, then out of necessity you can transfer the personal data. Next is, I think, just to continue on the necessity. So prior to making the transfer, you must ensure or ascertain that the transfer is strictly necessary. So definitely there are going to be justifications involved here. And then you're going to make sure that there are no fundamental freedoms or risk on the data subjects that, override the public interest necessitating the transfer. So you're going to have to do like an impact assessment on this. And then the basis does not affect the operation of any international agreement in force between Kenya and third countries out of the judicial cooperation in criminal matters and police cooperation. So there are some levels of, accountability you have to do before you transfer personal data out of necessity. Then there is the consent. A data subject can also consent to you transferring their personal data outside Kenya. So, this is what you look into, that the data subject has explicitly consented to you transferring their data outside Kenya, and you have informed them of the risks involved in such transfer. So the data controller or processor must seek consent from a data subject for the transfer of personal data, and that is according to Section 49 of the Act, which sets out the parameters a controller and a processor need to look into while they are transferring sensitive personal data. And some of the categories of sensitive personal data are like health data, family data, spouse data, marital status, sexual orientation data. We have property data. All that have been categorized as sensitive personal data. Moving on. So again, when you're transferring personal data outside Kenya, you must ensure that your recipient of this personal data, you have entered into an agreement to ensure that that entity that is receiving your data is able to safeguard, or you're able to hold them accountable for, safeguarding that personal data that, you're transferring to them. I think that is clear, and the entity, the agreement must be written. It cannot be oral. It has to be a written agreement. And then Cynthia talked about passive data transfer. Sometimes we are transferring our data, passively. You may not be aware that you're transferring personal data. So instances like this are in, for example, the cloud storage. We store our data outside Kenya. So many times it's deemed like transferring of personal data. So as controllers and processors, we must be very much vigilant and well informed of the entity or the service provider where we are storing our data, that they have commensurate or, they offer protection to the personal data that they are storing in their jurisdiction. And therefore we need to, do things like getting the consent of our customers or informing our customers that we do store your data in such and such a jurisdiction, and ensure that that other jurisdiction is able to offer the required and the necessary protection of that personal data. From here, we will invite Cynthia to take us through an overview together with Josephine on the Shrimps case.
Okay, so I would like to welcome Josephina to take us through this case, then we will move forward from there.
Good afternoon, everyone. Thank you so much for having me, Cynthia, and Brenda, for that amazing presentation. And as you were going through your presentation, I realized, a lot of similarities between the GDPR and, the Kenyan Data Protection Act. So I'm going to take us through the Schrems 2 case. And for those who may not be aware, the Schrems cases are, they are considered landmark cases when it comes to cross-border data transfers here in Europe. And this is because they literally put to the test the GDPR and shone a light into the limitations of some of the legislations that we have. So there is the first Schrems case, but they have similarities in terms of the facts. That's why we're going to be discussing the second Schrems case, because that's the most recent one. It was decided in 2020. So following the decision from the first Schrems case by the Irish Data Protection Commissioner, what happened was it invalidated what was referred to as the Safe Harbor Agreement. And this is a cross-border transfer framework that was entered between the EU and the US. Which facilitated for the transfer of personal data between the two continents. Now, like what Brenda already presented, it's pretty much the same here. Under Chapter 5 of the GDPR, that's where you find the conditions under which data can be transferred outside the European Economic Area. And it's the same. We have the adequacy decision. The second category is safeguards, having the appropriate safeguards in place, which includes things like the standard contractual clauses, as well as the binding corporate rules. All those, they fall under the safeguard measures. And the last is derogation, like what Brenda already presented. So what happened is that after the first framework was repealed through the court decision, Schrems filed another case. This is back, the decision that came out in 2020. And in this particular case, what happened is that Mr. Schrems was complaining that his data that was on Facebook was being transported to the US without the US complying with the requirement of the GDPR under Part 5. And this was because of the revelations that came out back in 2012 and 2013 by someone called Edward Snowden. He had exposed secrets of the US government, that they were conducting massive surveillance under the NSA. And also they have the Patriot Act, as well as the act that is abbreviated as FISA. And under those acts, the US government is not bound by standard contractual clauses or safeguards that are put on data that is transferred into the US. And after this revelation, that's when it was realized that even if you, on one end, you are following the requirements, you're complying with the requirements of the law, but there were limitations when it comes to the practicability on the other side. So I want to go through the key issues and analyses that were done by the court. And there were questions that were raised, and that was whether the privacy shield and the standard contractual clauses were adequate means of ensuring protection of the data in situation where transfers were made to the US. Because at this point, Facebook was relying on a new framework, which was called the Privacy Shield, as well as standard contractual clauses that were issued by the Commission. So they had these two instruments that they were relying upon to send data to the US, because as we know, Facebook is a US company, so data it gets sent to the US. Now, the analysis discovered that the court discovered that in order for the Privacy Shield to be deemed adequate, the third country must guarantee a level of protection that is equivalent to the protection of personal data in the EU. It was found that the US surveillance programs, such as those under the US Foreign Intelligence Act, they are not proportional or strictly necessary. So for the EU to accept, certain surveillances, they must be necessary. So the analysis revealed that the surveillance was not necessary. So if it is not necessary, then the US needed to comply with the Privacy Shield provisions as well as the standard contractual clauses. So the national security interest in the US were given a priority over the requirements of the EU law. And it was also that the ombudsperson mechanisms that is in the US was not sufficient to ensure appropriate oversight, and it lacked independence, and which means it cannot adequately provide the data subject, the administrative and judicial redress in court. So in other words, an EU citizen who is aggrieved by how data is handled in the US, they could not go to court and fight for their rights in the US because these instruments were limited. The standard contractual clauses, they were also analyzed, and it was discovered that the terms are only binding on the recipient of the data and not on the third country or its governmental agencies. Therefore, it is impossible to ensure that the government agencies do not have access to the data transferred by the standard contractual clauses. So government agencies were not bound. It was only the organization, the entity that received the documentation. So that makes the whole agreement null and void because it is failing to meet the purposes for which the instrument was created. In order for the SEC to be a valid mechanism, the data controller must examine the law of the third country and provide supplementary measures and additional safeguards where it is necessary to ensure that equivalent protection is provided. So the conclusion was that also the standard contractual clauses were not a valid safeguard in this regard. And that, so to just sum it up, there is a conflict between the provisions of the GDPR and some of the laws in the US. And that's why this is important, because on the surface, when you look at the law, Chapter 5 is telling you that when you comply with the provisions of these articles, then things should go through smoothly on the other end, that ultimately the privacy of the data subject is ensured. Ultimately, the data subject is protected. But when it came to the practical aspect of things, it shows through this case that it was impossible to enforce the requirements of the GDPR on the US government. And that is where, we can say this is like checkmate, because that is the situation until now. In the beginning of the year, there was a political announcement that, we are going to have a privacy shield plus. But again, as long as the US still has acts like the Patriot Act and the FISA that have not, as long as the US law is not amended to accommodate the required safeguards for EU citizens, it is going to be very hard to have that adequate decision, and companies will be forced to continue relying on derogation measures. And this is in Brenda's presentation, she said necessity. Under the GDPR, they say they use the term of derogations. So where, for example, the data subject will need to explicitly consent to their data being sent to the US. So that's what you're looking at. So the decision from this case, of course, the privacy shield was also revoked. So as we speak right now, there is no agreement between the EU and the US. So there's no adequate decision anymore, as these have been repealed. And until something is done with regards to the US legislations, this is where we are at the moment. And I think this is where we take lessons from what has happened here in the EU to see the challenges that are on the ground with this legislation. You have one thing on paper, but when you are dealing with different jurisdiction, you can come across, blocks like this one. You can come across situations where you're not prepared for. And after this case, that's where now you are hearing of transfer impact assessment. Now, transfer impact assessments are not expressly stated in the GDPR, but they became a necessity after experiencing Schrems 1 and Schrems 2. And I want us to go through some of the guidelines that an organization, a data exporter can consider, or a data importer as well, can consider when transferring data. So there is no specific guidelines on how to draft transfer impact assessment, but there are some recommendations of how an organization or an exporter of data can consider and look at while if they want to transfer data internationally. This first step is to describe the intended transfer. Now, how does one go about this one? You need to look at what data are you transferring, the categories of data. As you know, we have personal data that is, just personal data, and then we have special category data, and that depends on what is categorized as special category data in your jurisdiction. From my research, I've noticed different countries categorize different things as special category data. So it's important to understand what are regarded as special category data in your jurisdiction. It could not be special category data in another jurisdiction, but it's good to understand the parameters of that data that you're transferring, because the type of data that you're transferring will determine the type of safeguards that you need to have in place while transferring that data. So you also need to look at to which country you are transferring that data. What is the political situation in that country? The different conditions. What are the what legislations do they have in place when it comes to exercising access rights or personal, data subjects' rights? What are the requirements? Then the second step is to define the parameters of the TIA, and this is looking at the duration, things like the duration of the transfer. Is it going to be an ongoing, depending on the type of business that you have? Is it an ongoing thing? Is it a one-time thing, this transfer that you're doing is, and what laws need to be put into account? And this is the law of the receiving country versus the law in your own jurisdiction. What laws do you need to comply with, and the different legal requirements. Thirdly, you need to I added another point here, is to define the safeguards that are implemented. Of course, we have technical safeguards and we also have organizational or contractual safeguards. So it's good to know, does the data need to be encrypted or anonymized or pseudonymized? What needs to be done to the data in order for it to be transferred to a third country? And the same with organizational or contractual, that is the contract between the data exporter and the data importer as well. Is it needed? The safeguards that you are putting in place, are they recognized in the country where the data is going? So it is important, for example, the data can be sent through another country that has adequacy decision. So instead of sending it to a country that is more complicated, if it can be sent to a country that has an adequacy decision with your country, then maybe that's a better option. So it's good to do your research and understand which is the safest route for this data, because at the end of the day, the ultimate goal is to protect the rights of the data subjects. Then we are looking at to assess the risk prohibited lawful access in the target jurisdiction. So here is to understand the laws of the third country. If there are any basis, and this is where Schrems 2 came in, are there for third parties like government agencies to legally access the data despite you having safeguards in place? Because you could be playing your part, you have all the safeguards in place, but what is happening on the other end in the third country? And you can see the trick, the trick that is exposed by the Schrems cases. Someone could ask, suppose if Edward Snowden had not revealed the secrets of the CIA and the FBI, that they are conducting this massive surveillance on the international level and surveilling EU citizens. If that was not exposed, would we have known this is happening behind the scenes? So it's the same question, even as with other countries. What if governments are running secret projects that render the safeguards null and void? That is something to consider as well. So to conclude, we can say that whether or not the intended transfer of personal data to a third country involves an adequate level of risk. So the aim of this whole exercise is to see if, apart from you implementing all the required safeguards as per the Kenyan Data Protection Act, by doing this TIA, you are doing a further confirmation that am I ready to take the risk even after all this? And it is important to also keep in mind that it requires an in-depth knowledge of the legal framework governing personal data, both in your jurisdiction and in the third country. So it's not as easy. I know I went through, short on this point, but you need to understand there is an in-depth knowledge that is needed in order to have good results and to have something that would protect you from liability in case something goes wrong. So that's the end of my part, and I take it back to Cynthia to proceed with the,
Thank you so much, Josephina, for that presentation and analyzing the Schrems case for us and its implication on the cross-border transfer of personal data and how to carry out a transfer impact assessment. So moving on, I'd like to welcome back or invite Brenda once again to take us through the impact of the Data Protection Act on your entity and how to comply as well.
Yes, so when we talk about transfer of or cross-border transfer of personal data outside Kenya, one of the impacts we know is that a certain survey has put Kenya by 2020 to have 22.8 million internet users. And we know that 2020 was the wake of the COVID-19, and we saw an uptake or an uprising of, e-commerce, more people, using the internet for businesses, for advertising, for work, for socializing and all that. So there was an uptick of the use of social media. We can see it at 8.8 million. And then, of course, mobile connectivity is increasing day by day. And then we have over the top applications, that is WhatsApp, the Facebook messaging. And all this continues to be on the rise. And then again, one of the key ones is the mobile lending apps. We know that this also has had an uptick recently, with many companies, coming up to offer financial, reproof to people who are seeking for loans, to cushion them during these economic times. Cynthia, you can move on. So with all this, usage of the internet and technology, many of these companies or service providers are based outside Kenya, and they do continue to hold our data. They do continue to access the data, and in a way, data is being transferred across the borders. Okay, moving on. So on this slide, you can see that most of these apps, most of these service providers, they can access our contacts, they can access our location, they have access to the network connectivity of our data, the digital lending apps also. They can, they all have our data, and sometimes it's with, as I've said, third parties outside the country. A majority of the internet users in Kenya have little or no knowledge of the implications of giving our data. In Africa, we are very giving, we trust, and we are always giving our data out, and some of this data is stored or is processed across the borders. So unknowingly, we grant the power or the autonomy of our data, or what is decided on our data, to foreign companies or intermediaries outside. And that's why we are bringing in the aspect of cross-border transfer of personal data. So what can we do to mitigate some of these concerns that have been occasioned to us being a country that is very tech savvy? So we can seek to, to get from the controllers or a processor, or if you're in this attending this webinar, we can seek to know who is holding our personal data. Where are they based? Are they local? Are they, outside? Are they legitimately or legally processing this personal data? And then, is it possible for some of the apps, especially the fintechs, that have our borders, have the data across borders, and we know that most of their policies and practices are largely to foster their businesses and interests. So can we bring them to account? And we've seen the move by Kenya, and I know it was a collaborative initiative between the Data Protection Commissioner's Office and the Central Bank of Kenya to at least begin to regulate the fintechs, just in a bid to protect the personal data of its citizens, because we know most of this data is stored outside Kenya and is processed outside Kenya. And then we need to minimize the data we collect. So we need to bring to account the data that we collect from our customers, especially if you're a fintech, or you're a company that does a lot of cross-border transfer of data. And then we need to be more open and transparent on, and even share the reports and educate our users on how their data is handled, both here locally and internationally. And of course, we need to continue sensitizing and making people aware of their online activities, that sometimes they can be giving their data to organizations that outside Kenya, so that they can begin to to ask and, require these organizations to be obligated to protect their data, even as they use it to foster their businesses. Moving on. So what are some of the recommendations we have in this webinar and also going on? We can tell that for us as Kenya, this whole ecosystem of data protection is an ongoing process. We have not yet got there, and the office is working very hard to ensure that it has a footing on how it protects the personal data of Kenyan citizens. So in order to mitigate or manage the uncertainty of data transfers, and of course absence, because I've seen a question which is asking about does Kenya really have an adequacy decision as part of our law? And we haven't yet set out or got into these agreements with other countries, or to even list these other countries that have commensurate data protection laws or organization. But I believe the regulator is moving there. However, what we can do as we wait for the regulator and the whole data protection framework to get its footing is to be very to comply with the Data Protection Act, and also to carry out these extra steps that Josephina has talked about, having the TIA, the Transfer Impact Assessment. You can look into the jurisdiction where you're transferring this data. Do they have adequate protection for your data that you're transferring? Because at the end of the day, you as an organization or a company, you will be held liable if there's any breach or there's any violation of data protection of the Kenyan citizen. Moving on. Another recommendation, again, we know that we haven't yet, there is no clarity regarding the adequate data protection, jurisdiction and organization, or a pronouncement by the regulator on which organizations are, complying or have adequate protections. But again, as I said, the only thing we can do is try or comply with the act, because at the end of the day, if we do not comply, we can be held liable. And then if organizations like yourselves need any assistance in coming up with these agreements, because we've been told that for this transfer to happen, there must be an agreement between yourself, there must be corporate binding rules. So if you need any guidance on coming up with a data transfer framework for your organization, or any risk management solution, or the transfer impact assessment, you can always contact South End and have them guide you through some of these things, because you'll be dealing with experts who have people like Josephina, who have dealt with international organizations and have seen and can be very instrumental on some of these things. Moving on. Just to look at, yes, I guess we had finished. Maybe we can take a round of questions. Before I saw some questions on the chat. Checking from the Unwanted Witness, which is a civil society organization website, as of 2021, the question was, how many countries have ratified the Malabo Convention? And they have listed as 14 countries have signed onto the convention, but only 8 countries have ratified the convention. I hope those figures are accurate. If any of the panelists, Josephine and Cynthia, you can confirm this so that we can give accurate information. But as of that website, that is where we are at as a country, as a continent on this.
Actually, that is the true position of it. And at the beginning of the year, we had we had 13. So there's an addition of one country. And for the Malabo Convention to become binding, it means we have at least 15 countries to sign this, to sign and ratify the same. Yeah.
Okay, thank you, Cynthia. So we have another question from Winnie. Does Kenya really have the adequacy decision as part of our law? Yes, we do have that as part of our law. In fact, if you look at regulation, I think 44, it is part and parcel of our law. And I do know that Kenya has been listed as one of those countries in many jurisdictions as having adequate protection of personal data. However, the regulator in our country has not yet made any pronouncement of countries or organizations that have, commensurate or offer adequate protection, but we are really positive and we know that that's where we are moving as we go on in getting our footing on this data protection.
Okay, and Brenda, to add on to that, in Africa, I believe we only have one country that has provided actually a list of countries that they have the adequacy principle in relation to transfer of their data. And the only two countries from Africa that were appearing on that list was, if I'm not wrong, it was South Africa and Kenya.
Yes.
Maybe Josephina can confirm and add something onto that.
Yes. Well, to add in the European experience, when it comes to at least the provision of the GDPR, when it comes to adequacy decision, it can be issued to a country or a territory within a country or an organization. So it's not just a country. I haven't had the opportunity to go through the Kenyan Data Protection Act, so I'm unable to make a comparison. So maybe you can help me. But I think if the Kenyan law could make a provision that an adequacy decision is not limited to country-wise, but rather it can, be granulated to include maybe, an adequacy decision for an organization, an international organization, for example, the UN. So the UN operating in Kenya can have an adequacy decision while Kenya as a country does not have an adequacy decision, so as to continue to facilitate, organization carrying out their duties, doing business with this country. So that allows for the country, allows for the entity to be able to not to be limited by the fact that a particular country does not have an adequacy decision or a particular territory. So the GDPR allows for those different divisions. So that's what I wanted to add.
Yeah, actually, I just want to confirm that with the Kenya Data Protection Act regulations, that's exactly what also the law in Kenya provides for. So it can be a country, it can be a territory, it can be a sector, it can be, an organization, just like the GDPR.
Yeah, which I think in my opinion, it's a good start, because getting an adequacy decision, from what I've seen, it's not easy. There are a lot of criteria that, the commission has to go through, a lot of work, which if you look in reality, it involves a lot of money to investigate a country and be able to reach to that level. And with Europe, they've had data protection for many, many years, so in time, I believe even African countries will get there as we continue to enact data protection laws and growing in this area. We are going to get to a point where we'll have more countries, not just, Botswana, issuing list of adequacies. And the good thing is that when one country starts, it's easier for another country now to just take the research that has been done by other countries that have already treaded that path before you and have this list coming up. So I hope and believe we're going to have more African countries added to this list of adequacy. I don't know if Cynthia, you're going to take the next question, or can I go with it? This is from Polycarp. Moriasi.
Yes, proceed, Josephina.
Okay, so Polycarp is asking, he's looking at a scenario where data subject consents to the transfer of their data to a country which the data commissioner does not deem adequacy provisions. Will the data transfer still go through, and what options does the data commissioner have, remembering that the office is a regulator? So from my understanding is that at the end of the day, the regulator, the regulations, the law, they are there to protect the data subjects. But at the end of the day, it is your data. So the ultimate decision of whether data is processed or not is upon you, unless you have situations where it is necessary for public interest, or in the case of public health, like we had the COVID situation where you have no control over that. But as long as you have consented, and that is why consent is held in high regard, that has the data subject consented? If they've not consented, then you have these other conditions. So yes, the data transfer will go through when you have personally consented, but the onus is on the controller to make sure they have given you all the relevant, information with regards to how your data is collected, how it is processed, everything, the whole data governance, the whole life cycle of your data. If the controller fails to do that, then that's where the regulator comes in and holds the controller accountable. What the regulator does is to hold accountable entities, controllers, and processors who are handling your data, because once you've given that data, you don't really have much control as regards to what happens to it. So the purpose of these regulations and the regulators is to defend you once the data leaves your possession. Once it's in the hands of these entities, how is it protected? So I hope I've answered your question, and Cynthia and Brenda can add on to that as well.
Yes, you've adequately answered that question. Not unless the Polycarp, if the answer is satisfactory, you can let us know. Then I believe any other person will be having a question. Kindly, you can raise your hand or unmute yourself and ask the question before we close. You have still 8 minutes to go before we close and end the presentation. And for all our participants, thank you for joining us today. For those who wish to have certificates of participation, kindly email us. I'm going to share the email address of Southern Tech here. Then we can share with you the details on how to get your certificate and the payment procedures for the same. Okay, Polycarp says that thanks, the answer was satisfactory. Consent is key. Sure, thank you, Polycarp. Seemingly, we don't have any other question from the audience. Someone asked if we can share the presentation. So normally what we do is that at the end of this, we will have this on our YouTube channel. Kindly subscribe and also share, then you can have access to this content.
I would also like, just for learning purposes, I would recommend a couple of more cases. You already know, I spend so much time on cases. So if anybody's interested to learn more about, cross-border data transfer, at least the European experience, they can look at the Google versus Lloyd case. Let me write them in the chat, but there's the Google versus Lloyd case. It's a good case to look at. And then you have the Swift case. This is also very close to, it has almost similar facts as the Schrems case. And this was even before the Schrems cases. It gives a highlight of what happened to data through the Swift system. For those working in the financial sector, know about Swift. So there's a Swift case from way back. This was 2006. It's a good case to look at. And you also have the Google Analytics case, these are more recently. Actually, the Schrems 2 case gave birth to the Google Analytics cases, which are still going on around Europe, where Google Analytics is being declared illegal in some parts of EU. So far, we have, I think, about 3 countries in the EU that have already declared Google Analytics as, not, they shouldn't be used, as they are not strictly necessary cookies. And I guess that's a discussion for another time, but it's good cases to look at as well.
Thank you, Josephina, for those additional cases. I believe they will come in handy for our research and even working on our transfer impact assessments and everything. So with that, and for everyone who has stayed tuned up to this point, we really appreciate your presence and hanging around for that long. I hope you've learned, and I believe I hope to see you in our next webinar as well. So not unless there's a question, there's a concern, then I believe we are good to go, and have a great afternoon.